guy in Chattanooga, Tennessee, David Tulis.
The conversation between dad and son in my house often takes a turn on understanding your situation and understanding your rights. My son, the middle of three boys, is a man now and has gone to the Marines. He was an injured Marine, and he's now a retired war veteran with injuries under the VA's care. He had a collapsed lung at Parris Island on a long Saturday march, a 12-mile march, probably backpack full of rocks, and collapsed after a week of neglect by the unit, and so had emergency surgery in Charleston. And my wife Jeanette went to visit him in the hospital the day that the gunman killed 9 worshipers at the church. She in fact was there, saw coming out of the hospital, saw some of the TV crews giving their stand-ups near the church where Dylan Roof killed 9 Christian people at an event. People say he's a white racist. I would say it's probably an anti-Christian. Probably anti-Christian is probably the bigger usage, the more apt usage to describe his act. It was against innocent people in Christianity, in a Christian context, worshiping God, invoking God's name as they discussed the problems of the world around them, thinking to do better for their fellow men. And here Dylan was against that, of course, and then against also the tiny fact that they happen to be black. And yet those people who were lying strewn in the church meeting area there had all the same body parts that he did: shoulders and ribs and hearts and spleens, livers, and toenails and fingernails and nose hair. The men who were lying deceased or near death had Adam's apples as he did, and eyeballs and earlobes and hair. They all had the same things except for one distinctive, and that was that their skin color, which is a very minor. I mean, pigmentation is a minor percentage of one's data. They were the wrong color according to his thinking, and so if you killed them, there would be a race war ignited somehow. That is, of course, a revolutionary concept. That is a concept of revolution that Marx espoused, that the revolutionaries from the 1840s on thought in those terms. They thought if we just start a war, start a killing, that's what John Brown did. And he killed black people. John Brown killed black men, black farmers, I think in Arkansas. He was a one of the early terrorists. If we just kill enough people to be a war, we can start a war by murder. A mistaken idea, no doubt. And the son and I were talking last night on the phone. His mother took over after I did, asked about whether he is having an honorable relationship with a young woman. And my conversation was tending into another topic, and I kind of used up my time on the phone with him, that Lord's Day conversation among family members, asking about his use of the motorbike that he has. And he says he's been stopped innumerable times by police. And police, he says, well, Dad, just treat him respectfully. He's a very smart, yes sir, no sir kind of guy, and very respectful. And he asks questions of police officers such as, why are you traveling in an unmarked car? You're not giving me notice who you are and what your intentions are. Why should I stop if I don't know, if you don't have a vehicle showing that it's making public display of its public service, and not some malefactor with $30 dashboard lights that he bought online. How do I know that you're not that? And so he'll have intelligent conversations with cops. And so I said, son, just remember that State versus Garcia, 2003, Tennessee, and that State versus Raspberry, an appellate court ruling in 1982, make it very clear that when the blue lights are flashing, you are under arrest. And that if you're under arrest, you need to not make chit-chat and not give away your rights. And I told my son that he should make note of some very valuable work being done in Texas by a former police officer who has had run-ins with the law, but who is giving, you might say, ammunition for those who are insisting that if they're innocent, they plan to play innocent at the first encounter there at the traffic stop, and that is to insist that that there be probable cause for the stop or articulable suspicion, and that person is not going to waive any of his rights. And that is a discourse by a writer named Eddie Craig, who's developed a whole transportation script that I've studied pretty carefully. And I'm thinking about it. I might throw in State versus Garcia and State versus Raspberry 1982 as part of the discussion, right? The discussion that presses the officer and the officer's goodwill, because officers are impotent to act unless they have probable cause. This question has come up in the Gaddy case in the beleaguered city of Dunlap. I say the city's beleaguered because if one person is beleaguered outside of law, well, then everybody is beleaguered, and no one is safe. If you have a mayor such as Mayor Dwayne Land, and you have also a circuit court judge acting in city court in Chancery Court there, acting outside of his authority, no one is safe, and that's the danger of lawlessness by the bench, lawlessness by the executive branch of city government or any other government, is that if these good people can get away with grinding one poor soul into the ground, well, then no one is safe, and everyone should be complicit. Everyone should be compliant. No one should say anything. We should all live in fear, and living in fear is what our life today is all about. Look on the national sector. The smallest problem our country faces is terrorism, and yet we've made it the biggest one. It's the smallest problem that we face. It's smaller than most every other problem that we can discuss, and yet because it's been magnified by the evangelical argument of the terrorist, right? He's making a religious argument. We have believed that argument. We have been convinced by it. We have been converted to it, and we all live in fear. And so our salvation is not in God. It's not in the armed citizen. It's not in confidently living a righteous and good life in our private spheres, in public, in our towns and counties, and in our states. Our solution is the national government. It is the police state. It is search and seizure without warrant, actions against individuals without precaution, and without warrant. In other words, without the judge being petitioned by a person making a sworn statement under oath and under penalty of perjury that a crime has been committed by so-and-so, or that so-and-so is involved in a crime of some kind, or has contraband on his person, and should be thereby searched or arrested. That's what a warrant is about. And searches are illegal in Tennessee. They're simply illegal. Okay, got that? They're illegal, except under warrant. And when the blue lights flash behind you, you are under arrest. Okay, that's 2 cases, and I'm getting this from my well-worn printout from Tennessee jurisprudence. And the printout is for arrest. It's the study of arrest in Tennessee, and all the cases that define the statute, define the right as by the judges. So we have a constitutional right to be free from searches and seizures in the Bill of Rights. And so how does that right play out when you have a law prohibiting theft, right, prohibiting murder and other crimes that are common law crimes that have been adopted by the legislature into the statute, so they're statutory offenses. And when there's an offense done, how is the search conducted? And so the question is the play of liberty of the individual and the necessity of the state to capture, to hinder, and thwart, and bring to justice evildoers, rapists, robbers, thieves, hit-and-run travelers on the road, and people like that. Those are all ones who need to be they need to be caught by the people. The people need to catch them. The people need to bring them to justice. And so I'm bringing up to my son this question. So I threw at him yesterday, State versus Garcia. Okay, just remember that, State versus Garcia and State versus Raspberry. If the blue lights are on, you're under arrest. And so, son, just be careful. Don't make small conversation. And I asked him about carrying his pistol, and he says, "Oh, I open carry, Dad." and so he does. And he's a very liberal young man, you might say. And he has joshing conversations with cops at stoplights, and they see he's opened his pistol on his hip, and they say, "Is it a Glock?" "No, it's an S and W." This is the Tulis boy, being a man in Nashville. He says that Nashville cops are cool, Chattanooga cops are bad. This is his analysis, and so I'm hoping to get from Pete Woodward, who runs Blue Ribbon Cycle, word about what his clients are telling him on this point. Now, I want to get to something that touches on the whole Gaddy story and the abusive process, and why many people are in the court in the first place, in Chancery Court in Hamilton County and elsewhere, and also in Circuit Court, where you can have court cases in equity. You can have disputes handled in Chancery. You can have disputes handled in Circuit as well. Now, there is an injunction that I was reading in my Bible readings this past week that just jumped at me again, and it's St. Paul in the 1 Corinthians chapter 6 about having a matter. He's talking, of course, to Christian people, and I mentioned this to you, my listener. You're not a Christian necessarily. I understand that, but as we know, the Bible has tremendous influence on all of modern culture, even in a time of declension, Christian declension, religious declension. There is still a tremendous influence, and I'd say that the declension is in many points is gone, and that there are strong gains to be seen in Christendom, not in this country, however, mostly in other parts of the world. But there is you might say a prohibition of Christian people suing Christian people in court. In other words, if you are a Christian and I'm a believer too, maybe we're in different denominations or different churches, and we have a business dispute and we just can't settle it, and you sue me. Okay, let's say you sue me, you're the aggrieved party, I'm the offender, and we go to Chancery Court. Pam Fleener might hear the case, Jeff Atherton might hear the case, or we go to Circuit Court, and if it's under, I think, $25,000, it can be settled there, often without attorneys present and by the two parties directly. But is that the best thing? And the prohibition against two Christian people being in court together has startling implications if we just think about it. Paul says at 1 Corinthians chapter 6, verse 1, he starts off this section by saying, "Dare any of you having a matter against another go to law before the unrighteous and not before the saints? Do you not know that?" And here he's going to talk about how the saints are the people who will judge the world. Okay, if they can judge the world, he's asking, how is it that you in the church go to people who are not in the church for justice? Do you not know that the saints will judge the world? And if the world be judged by you, are you unworthy to judge the smallest matters? Do not know that we shall judge angels? How much more things that pertain to this life? In other words, if Christians are going to be judging angels in the next life, how much more should they not be judging the things that pertain to this life, as he says? If then you have judgments concerning these things pertaining to this life, do you appoint those who are least esteemed by the church to judge? Now, who are those least esteemed by the church? Well, those least esteemed by the church are those who are not in it, right? Those who are not part of the covenant, who are not professing believers in God, who reject God in some way and have some other system of law and obedience to which they adhere and serve. I say this to your shame. It is so. Paul says that there is not a wise man among you, not even one, who will be able to judge between his brethren. It's a question. But brother goes to law against brother, and that before unbelievers. Now, therefore, it is already an utter failure for you that go to law against one another. Why do you not rather accept a wrong? Why do you not rather let yourselves be cheated? No, you yourselves do wrong and cheat, and you do these things to your brethren. So in other words, you go, you who God esteems as members of his elect, go to people who reject God and try to get justice there. And there is a brother has aught against brother. In a small matter, he's suggesting, why don't you just allow yourself to be abused? Why not you just let little controversies settle among yourselves? Shall Christians have the honor to sit with the sovereign judge? And are they not worthy to judge the trifles about which you contend before heathen magistrates? Asks a writer discussing this chapter. You who value yourselves so much upon your wisdom and knowledge, is there none among you that has wisdom enough to judge in these differences? Must brethren quarrel? Matthew Henry says, and the heathen magistrate judge in a church so famous as yours for knowledge and wisdom. And then this passage also makes a wonderful point that the least Christian is better than the best jurist outside of Christendom to judge a matter. The least esteemed member of your church or the other man's church is a better judge than Judge Fleener or Judge Atherton. Both of those, I think, are practicing Christians. But the point that Paul is making here is that the court system is not godly. It has an alternative and a conflicting standard of justice than God Himself ordains, and has a wrong sense of equity, right? A wrong view of eye for eye, tooth for tooth, and will not bring justice and not bring a remedy to the disputants. Okay, so the question is, if God requires Christians to settle disputes among themselves, why do we not have in churches in Chattanooga court systems? Why do we not have a practiced and well-oiled system in which deacons hear disputes? They take application for trials by people who have disputes, and then they organize men in the church to hear cases periodically. Let's say every 2 days a month there is court held by church. And the parties who are not Christians at all, maybe people who are just outside the church entirely, but hear about this system, they can pay to have Christian men sit on their cases and hear their cases. Some of these cases could go a half a day, some could go for a day, some might last longer. And so not every Christian man could be a part of such a venue. But think about the prospects. Think about how if Christian people could settle disputes among themselves, they could hear outside of Hamilton County court system. They could have their arguments heard, weighed, the evidence is considered. Rules of court could apply there too. I mean, that court could borrow some of the very fine workings of the legal system that we have today. Not necessarily, but it could, and thereby deliver justice and equity, remedies for a situation. Chancery court, if you read the history of it, as I have read in Gibson's Suits and Chancery, the whole first couple chapters is about how Chancery Court got started. It came in England in the 1300s when members of the church that were called chancellors, they were high officers in the church. Before the time of Henry VIII, they heard disputes and brought peace to the land. And finally, it became its own court. It became a Chancery Court. That is, of course, lampooned by Dickens in Bleak House, where the case goes on and on through generations, never being solved. Jarndyce versus Jarndyce in that wonderful novel Bleak House. But Chancery is a place where disputes are heard. We have that available today. Chancery is a wonderful jurisdiction. I would say that if you have an argument, take advantage of it there. It's a great venue, and the judges we have in Chattanooga, I'm confident, are outstanding. Pam Fleener and Jeff Atherton, they have outstanding credentials to hear a case, and they are man and woman of equitable temperament, and jurisprudence. Now, the question, I guess, comes with these other prospects. Jackie Schulten, for example, she goes by Jackie Schulten Bolton, now runs a mediation service, and so there are less expensive ways, maybe less time-consuming ways of having justice resolved, justice obtained by arbitration. These are good developments. They are free market developments, and I think the trend will continue. The question, I suppose, is, since it is Monday, the second day of the week, Sunday being the first, in which Christian people went to church and worshiped God, they come off of their worship now. They're beginning their second day of the week, refreshed, ready to conquer the world. What has the Christian church done in Chattanooga in this direction? What have churches done? Let's say City Church in Chattanooga. Is there a place where two people who are having a dispute, maybe not even members of that church, could go and have godly men hear the arguments and without personal prejudice weigh the arguments and then weigh the Word of God, right? Weigh the Ten Commandments and the details that express God's fairness, God's justice, right? God is, he's not necessarily fair, but he's always just. He's always just. And if his system is honored and feared and revered, good results will come for both of people in a dispute. I'm thinking that we need to have an expansion of the interest in the church on the outward workings of society, not just personal holiness, not just holiness within the family, but what does Christianity have to say about the larger issues? I think we can start with this ban by God through the words of St. Paul against Christians going to law against each other before the unrighteous, right? Before people outside of the holy covenant, who make no pretense of loving God or caring about God's justice, God's truth. Rather than go there, cannot Christian people come up with their own venues, their own tribunals, if you will? Well, this is David Tulis. Love your neighbor and buy local. Now, I've got some important messages now.
The Tennessee Valley's news, talk, and sports leader, Nooga Radio.